Hello, everyone. Good afternoon. Welcome to today's webinar, Illegal Nursing Home Debt Collection Practices, Protecting Residents and Families. I'm Lori Smetanka, Executive Director of the Consumer Voice, and we're really glad to have you with us today. So we're doing this webinar today because we know that the Nursing Home Reform Act prohibits third-party guarantees of payment for admission or stays in a nursing home. But despite this prohibition, there are some facilities that are trying to collect residents' debts from residents, from relatives, friends, or other third parties if a resident can't afford to pay. They've hired debt collectors to demand payment. Some of the facilities have reported the debt as belonging to a family member or a third party and have even sued individuals in court. And often these practices violate the Fair Debt Collection Practices Act and the Fair Credit Reporting Act. So the Consumer Voice has partnered with the Consumer Financial Protection Bureau for today's program, where we'll talk about these practices, discuss resident and family rights, and offer strategies for assisting residents and families faced with inappropriate debt collection practices. Next slide, please, Libby. A disclaimer that the Consumer Voice, as I mentioned, is hosting the webinar today on behalf of the Consumer Financial Protection Bureau, and as such, the panelists' opinions or views are their own and may not reflect CFPB's views. This program is public and all remarks are considered public, and as you heard, the webinar is being recorded and the information learned will inform CFPB's work. Next slide, please, Libby. For those of you not as familiar with us, the Consumer Voice is the leading national voice representing consumers and issues related to long-term care, and we do our work by advocating for public policies that support quality of care and quality of life. We work to empower and educate consumers and families with knowledge and tools they need for self-advocacy. We train and support individuals and groups that advocate for consumers, including long-term care ombudsmen and citizen advocates. And we promote the critical role of direct care workers and best practices in quality care delivery. Next slide, please. A few housekeeping details. You did hear now the program is being recorded. Please use the Q&A button on your control panel for posting questions for the speakers. After the presentations, we'll take questions as time allows. The chat feature can be used for comments or to respond to questions from the speakers or other attendees. An evaluation will pop up when the webinar is over, so please take a minute to fill that out. And links to the slides will be posted in the chat box and will be available also on the Consumer Voice website. Next slide, please. We have a terrific group of speakers lined up for today, including Anna Anderson, who is a staff attorney at the National Consumer Law Center, where she focuses on student loan and nursing home debt issues. Prior to being at NCLC, Anna was a supervising attorney at Legal Assistance of Western New York, where she oversaw the Consumer Protection Unit. Anna is the co-founder of the National Coalition of Nursing Home Debt Advocates, and works with advocates across the country to help stop illegal and abusive debt collection practices in the nursing home industry. We also have with us Alana Russell, who is a licensed clinical social worker in New York. She has over 20 years of experience working with older adults as an agent of support, guidance, and advocacy, and has advocated for and represented the myriad of needs of adults in long-term care settings. Currently, Alana owns a private geriatric care management business called Aging Connections, where she partners with older adults and their caregivers to help identify the resources and services that exist in their community, and she helps navigate the options to find the right solution for the individual. Beverly Yang is an older Americans policy analyst at the Consumer Financial Protection Bureau. Beverly specializes in older adult medical debt, planning and paying for long-term services and supports, and helping older adults make critical financial decisions after the death of a spouse. Beverly spent 7 years practicing consumer and housing law as a legal aid attorney before joining the Bureau. And you all know Sam Brooks, who is the Consumer Voice's Director of Public Policy. Sam is an attorney formerly with the Aging and Disabilities Unit at Community Legal Services in Philadelphia, where during that time he became an expert on nursing homes in Pennsylvania and nursing home regulations. Sam has a passion for justice and years of advocating on behalf of nursing home residents. So we're delighted to have all of you with us today. Thank you for taking the time to do that and for your partnership at the CFPB, Beverly. And with that, I'm going to turn it over to Sam to get us started. So next slide, please, Libby.
Great. Excuse me. Thank you, Lori. And it's really nice to be here with all of you today about this really important issue. And again, we want to thank Beverly and CFPB for really digging into this issue and really making it an important matter for residents and their families. As Lori said, I'm the Director of Public Policy here at Consumer Voice, and we're going to get right into the meat and potatoes of this issue. Next slide, please. Next slide. So let's talk about what third-party payment agreements are. It's in any contract that says a caregiver, a family member, a friend must pay the resident's bill if the resident is unable to or does not pay for whatever reason. These are contracts. They generally occur most of the time. They're included in the admissions contract that is presented to a resident and their family or their loved ones at the time of admission to the nursing facility. Sometimes they can be presented after the admission, but generally it's going to be wedged in among dozens and dozens of other pages of documents. And that's really the thing here. And that's really why we are so glad that CFPB is and others are really interested in this issue, because oftentimes these contracts are presented at very stressful times for both residents and their family members. Residents are at sometimes their lowest point. They can be. Being admitted into a nursing facility certainly isn't a wonderful thing to be doing. And they can be presented with this long list of documents and asked to sign. And it can also be very stressful for family members. And there's lots of things in these documents. And oftentimes when you come to these third-party guarantees, they're not explained sufficiently. They won't be adequately explained by staff. They'll say, "Oh, it's no big deal. Medicare or Medicaid will pay for this. This is just something we just have everyone sign." And oftentimes people sign these documents not knowing their rights around them or just what they mean. And I think this gets to sometimes a larger issue around nursing home care, is how it's paid for, who pays for it, and how those things function together. Is Medicare paying? Is Medicaid paying? And that's another, certainly a whole other webinar than this one. But oftentimes facilities will take advantage of that process and just kind of overwhelm folks with all these documents they need to sign. People will see arbitration agreements, which many of you know, which are documents that they'll try to get residents to sign saying they'll go to arbitration. And these documents are never in the interest of residents. Just like a third-party guarantee is never in the interest of a family member, a loved one, or anyone else to sign this document. And we're going to get more to the legality of them in a second. But frequently, people sign these and they don't even know they've signed them. They only know when they start getting bills or collection calls and say, "Oh, well, remember when you signed in, when you signed in your loved one or your mother or your brother, you signed this document saying that you would guarantee payment for this stay should payment not be made for whatever reason." And we're not talking about residents that don't want to pay. Sometimes we're talking about the myriad issues that present to residents that limit their ability to pay. So next slide, please. The great thing about it is they're illegal. Well, I mean, the easy thing about it, I want to say the great thing about it. Included in the discharge and transfer rights and admission rights of the federal regulations is a prescription that a facility must not request or require a third-party guarantee of payment to the facility as a condition of admission, expedited admission, or continued stay in the facility. So they may not say you have to sign this in order to come in. They may not say you have to sign this in order to come back, say from ER stay, and they may not say you have to sign this in order to stay. So it's a black and white proscription that says this cannot be done. The paragraph does go on to say that, however, the facility may request and require a resident representative who has legal access to a resident's income or resources to pay for facility care to sign a contract without incurring personal financial liability. All that means is you will help if you can help facilitate, or you have the power to facilitate payment from the resident's money, you will help that. But you can never, they can never require you to pay for it. Despite this prohibition, and that's why we're having this webinar today, facilities will still include these provisions in the admissions contract. And again, even though it's not allowed under the law and under the regulations, they will still try, and they take advantage of these of people. People will get a call from a collection agency or from someone else, will get a letter say you have to pay for this. And it's just like any other collection agency. They're hoping to take advantage of you, to prey upon your desire not to be in debt, or prey upon someone's desire not to be in debt, and hope that you'll pay it. Hope that you won't know your rights, or know, excuse me, the rights of the family, and in the rights of the resident. We're going to talk more about that today. I'm really excited for Anna and Alana to talk about, some ways around that. But when the most important thing is here is when you're being admitted to a facility, your loved one does not have to sign a third-party guarantee. And the things to look for are these are kind of buzzwords or red flags, or responsible party and joint and several liability. That's more of a legal term. But these are things to look for, and we'll talk more about that throughout the webinar about, kind of red flags that go up. And I think that's my last slide. Is there another slide? No, so I'm very glad to now turn it over to Anna and Alana. Thank you.
Thanks, and I think Alana is going to get us started here just to talk about how we have approached these cases, both from an attorney perspective, but Alana specifically from an ombudsman perspective. And I think with that, I'll pass it over to Alana.
Thanks so much. I appreciate it. Yes, so my involvement in these types of cases goes back a few years. Specifically, I was an ombudsman program manager for a local program in New York for 7 years. I've been out of that position for 3 years. However, I continue to do contract work with that agency on a group I've established that I'll talk about towards the end of my time. But to provide the background, back in November 2016, CMS established a rule in which nursing homes needed to send discharge and transfer notices to the local ombudsman programs. And as the manager of that program, I received those. It obviously took time, and I think our first notice came in January 2018. And this one got my attention specifically because it was for the reason of non-payment, and the bill was quite high. And just kind of going through a timeline, by May of 2018, I had received 5 notices in one day from one particular facility. And I think between January 2018 and May 2019, we had received 25 notices from this one ownership group of nursing homes in our region. So what I did as a ombudsman who has a social work background that I found helpful is, first I got organized. I created a data tracking sheet. It's an Excel document, has all sorts of categories. I would always be happy to share that if somebody is seeking a template. But the next thing I did was I visited the resident, and I really wanted to get a sense of their capacity to make their own decisions and their understanding of this notice they were receiving that was really, quite frankly, threatening to move them to a further away facility. I provided a lot of education to the resident as well about their right to appeal, what this means. And I did a lot of interviewing of staff, typically social work or the business office, the administration of the facility, to get a sense of, well, how did the bill get this big? What efforts have you tried to make to remedy this in the past? And then I advocated. I helped file appeals if that's what the resident wanted. And ultimately I attended many hearings, which was quite a new experience. From these notices, what happened to the residents, it was a mixed bag, but many of the residents did actually get transferred out. They lost their appeal. And for our region, what was happening is they were moving from Rochester to a town about 90 miles away. However, it's going from a city setting to a rural setting. So many residents did move, and some residents or their representatives signed agreements to make it go away. I had maybe one resident that moved to a different facility, probably of lower quality. And then I had a few residents that left against medical advice, which, although it's an option, it's certainly not ideal. And then a few notices were rescinded, and I had one resident that they were able to pay in full, which was wonderful. However, that is not a common option for most individuals. What I was able to take away is the reasons behind the non-payment were really three. It could have been due to financial exploitation. It could have been due to what I just call wanted to have my cake and eat it too, just by a competent adult saying they're choosing not to pay the facility. But the third one I think is really our focus today. And it fell into this category of I didn't know I was expected to pay like the NAMI. And to me, that was about education. The resident and or their representative were not appropriately educated about what they signed and what would be expected. Two case examples that I think Anna will end up talking about as well, that they started with me but ended with her. I had a gentleman who had been in a facility for maybe a little less than a year, and his bill was $95,000, which seemed quite high. And the story went that his step granddaughter was his power of attorney. And actually she was the power of attorney because her father, who was this resident's son, had in the past actually financially exploited his parents. So this granddaughter was doing the right thing, stepping in. And a lot of money was held up in an estate from this resident's wife passing away. And that process, like the bill accrued during that time. This particular resident, I don't love the phrase, but he is an example of he ultimately paid the price. He lost his appeal. He was transferred to the further away facility. And soon after COVID hit, and this particular facility really was at the nucleus of the height of COVID, and he contracted it and he actually died a few weeks later. And this step-granddaughter the whole time had made several offers to settle, arrangements to try to pay. She was a younger woman who I think was out of work at the time, new mother. So just a very challenging, sad story altogether. Another case example that we worked quite hard on is a woman, she owed much less, about $37,000. She lacked capacity. Her partner was appropriately advocating for the woman to not be moved. The resident ultimately was moved equally to about 90 miles away. Her partner didn't have a car, I think relied on the bus system and or renting cars to visit. Ultimately, that case was equally quite frustrating. They were never educated appropriately on what NAMI was. The partner was ultimately sued as well, as same with the granddaughter in the first case. My opinion of the challenges of these cases is they're very time intensive. It really, as an ombudsman, I felt like I was doing case management similar to a social work in a variety of settings. One of the other challenges was the difference in focus and in perspective. I, as an ombudsman, was focused on the individual and the impact to the person. I was very focused on transfer trauma, on that individual losing their providers that they have had in Rochester. And the facility, with all due respect, was focused on the business aspect about being paid. And I understand both sides to that. Another challenges was limited resources. Our ombudsman program relies heavily on volunteers. These are very complex cases. My program made the decision to not give these cases to volunteers, so it really did tax the paid staff that I had. And then regulations. Regulations were a big challenge in terms of how one can file an appeal, who can file the appeal, that you leave a message, they don't call back, or they do, and they didn't want to speak to me, they want to speak to the resident who didn't have capacity, etc. So one thing that finally, it's like I refer to it in my world as cue the angels singing. As I said, in January 2018 is when I received my first notice. And probably 6 months later, I realized I need help. These cases are really something else. And at this point, it was just the ombudsman going out. So a takeaway is I reached out to our local legal assistance agency and spoke to an attorney that I had known for a few years through our work. And I told him about these cases. And that was my major pivot point. This attorney went out to visit a resident with me and ended up representing the resident in one of these situations. And that just became appropriately contagious. And out of that, many more residents from that point forward had legal representation at their hearings. And then most importantly out of that is we were able to establish in November of 2018, something that I've called the Transfer Task Force. That is a group that has about 25 to 30 members at this time. It's a statewide group in New York, and representation from local ombudsman programs, local attorneys, that could be private attorneys or nonprofit attorneys. We have actually representatives from the Attorney General Medicaid Fraud Control Unit that attend, Adult Protective Services, and Center for Disability Rights. It's a fabulous mix of professionals all focused on the same concerns. And we talk about cases, we provide our own experience or brainstorming to support the individual that has a case, as well as we focus a lot of our energy on what legislative or advocacy changes could we make. So really my suggestion to the group today is build your network. That really changed the whole path for me in these cases, especially if you're going to build a network. I would build it with your legal support agencies that are in your community. Once again, private attorneys. For me, it was our county elder law board and the local legal agencies that were nonprofit. I offered to do in-services on the role of the ombudsman, on the topic of financial exploitation, could be on the topic of admissions contracts. And I just talked about these cases. I normalized that this is happening. I wanted the world, quite frankly, to understand this happens and it's of concern. And it's a legitimate practice, but it's of concern. And the last thing I did was really teaching my ombudsman volunteers of what to look for. They are the ones that were going into our facilities regularly. So what are, whether it's signs and symptoms of financial exploitation, or just keeping those connections, those networks in the facilities so that the social worker could potentially inform the ombudsman, hey, this is creeping up. We have concerns about their bill. The ombudsman's not the bill collector, but to kind of keep your ear to the ground as to, well, what's the latest with that? Here's some suggestions. Have you tried this? So I will hand it over to Anna, who really, as I said, I feel like I started at the inception of these cases, but Anna took it to a whole new level. Thank you.
Well, thank you so much. And I just want to say that I would not be focusing on this work at a national level today if it weren't for the ombudsman volunteers and Alana specifically for raising these issues to our attention. As I think you've already heard, I come from a legal aid background, but I actually did not specialize in elder law issues. My focus primarily has always been on consumer law issues, and my sort of bread and butter casework were representing people who were being sued by debt collectors, mostly for credit card debt, but occasionally medical debt billing cases would come up as well. I had never heard of someone being sued for a loved one's nursing home bill until probably about my third or fourth year practicing. I got a random phone call from a gentleman who was distraught, who told me that he was being sued for over $100,000 for his mom's nursing home bill, and that he could not find anyone to represent him and defend himself in the lawsuit, despite the fact that he had income and he could pay someone to represent him. But all of the attorneys that he went to just told him over and over again, it's not worth it to fight the nursing homes, just pay them and make this go away. This was a person who, yeah, even though he was working, he had a home, he still felt like he shouldn't have to pay his own money for his mom's very expensive care, given that the nursing home wasn't even trying to, get paid from his mom's funds or his mom's estate. And it was devastating because at that point in time, I had to tell him, we can't help you. This is not something that I specialize in. And unfortunately, the person wouldn't even have income qualified for our services to help him. So that case really stuck with me because it was someone that I know ultimately was probably forced to settle with the nursing home for a bill that he should not have been responsible for in the first place. So when I started getting calls again from Alana and our elder law attorneys at our legal aid organization, saying, that this was happening and coming up again, and it just did not seem right. Most of the time we were seeing it in conjunction with these non-payment discharge proceedings. So the resident was not paying their bill for whatever reason, and they were facing a discharge or a transfer proceeding from the nursing home as a result of the non-payment, while simultaneously their loved ones were being sued in state court for the bill. And so what I did is that I went in and represented the family members and the residents if they were also being sued in the state court action to try to get those cases dismissed. The biggest things that we are seeing in these lawsuits, when these lawsuits come about, the nursing homes are suing the family members. Sometimes they're not family members, but they're just a connected caregiver, a friend or some other, special person who's helping out the resident. They are suing them most often for breach of contract and then fraudulent conveyance. And breach of contract, that's what we've been talking about a lot today, is where folks have been signing these admission agreements, saying that they're the responsible party and they will make sure that the bills will get paid out of the residents' funds. And if they don't follow through with that, then they agree that they're going to pay it out of pocket. While we know that under the law, third-party guarantees are illegal, there is a loophole that basically says that nursing homes are still allowed to ask for someone to be a responsible party, so long as they are also not telling that person that they have to be financially responsible for the bill out of their own pocket. So it's a little bit of a tricky loophole that nursing homes are sort of getting away with, that they then use to pressure families into making sure that these bills get paid out of their own pockets if the resident can't pay it out of their funds. It's very complicated, but what it comes down to is that the nursing homes know that these family members and these loved ones, they're not going to have legal advocates to represent them in these cases. And they also know that when they do have legal representation, if they get in front of a judge, they can be very sympathetic and tell the judge, hey, we are just a nursing home. We provided all these services. We went out of our way. The care costs are so expensive here. We need to get paid. And the judges will be sympathetic towards the nursing homes on this and say, you know what? Yeah, nursing home, you should get paid for the work that you've done here. You provided a lot of really valuable services to this person, and we want to see you get paid. So we have run into this situation over and over again, where even though there is a ban on these third-party guarantees in these admission agreements, nursing homes are still getting away with it, and family members are still being held liable for their loved ones' nursing home bills. And that's because of these tricky, complicated loopholes with the responsible party clauses, but also because we've just seen bad decisions come out of the courts that hold up these judgments and basically make family members pay for this. So what I will say is that we're making a lot of progress here, and we're really grateful to the CFPB for stepping up and providing a lot of guidance and tools for caregivers to make sure that they are protecting themselves and enforcing their rights when they are helping their loved ones get into a nursing home, but also after the fact, if they've been contacted by lawyers or debt collectors trying to seek payment on these bills, to know how to respond to them. And I want to just walk you through an example. Alana spoke a lot about some really good cases that we've been able to work on and we've helped get dismissed. But basically what, I want to frame it for you is with one of my very first clients. She was not actually a relative of the resident. She was a family friend. And she was 78 years old herself, and she only had Social Security income, but she did own a home. Her friend needed to go into a long-term care facility after a really bad illness. She went right from the hospital to the nursing home. It was a very quick turn of events, and her family friend was the only one who was around who could actually assist this person in making sure that the admission process went through steadily. So this family friend signed all of the paperwork, signed the admission agreement, and even assisted the social workers in getting the paperwork that they needed to get the Medicaid application completed. And this woman was told by the social workers at the nursing home, we have everything we need. You do not need to do anything else on behalf of your friend. We will make sure that the Social Security checks will come to us now. We are going to be her representative payee. She's going to get Medicaid. Her only income is SSI. She's going to qualify. Don't worry about it. We've got everything. You don't need to assist us any further. So that was the last that this person ever really engaged with the nursing home on any of the billing side of things. And unfortunately, her family friend passed away in the nursing home about 6 weeks after she was admitted. 6 months after her friend passed away, she got a letter from a law firm saying she personally owed the nursing home, and this is a public nursing home, it was a public facility. She owed the nursing home over $15,000. This woman was flabbergasted. At first, she thought it was a scam. She did not even think to call the law firm because she just knew that this was something that was totally ridiculous. There was no way that a 6-week stay in a nursing home for her friend, who absolutely should have qualified for Medicaid care, would cost her personally $15,000. But unfortunately, it ultimately did lead to a lawsuit. And in the lawsuit, she was sued for $21,000. The number had somehow gone up by several $1,000s in that intervening time. And she was sued for breach of contract for failing to pay the bill out of the resident's funds, despite the fact that she never received a bill, and the fact that she helped the nursing home get everything they needed for the Medicaid application, and was told by the nursing home that the nursing home would start getting the Social Security checks of her friend to make sure that the NAMI was paid. Despite that, she was sued for breach of contract. She was also sued for fraudulent conveyance. Fraudulent conveyance essentially is a claim by the nursing home that this person stole or misused the resident's funds to defraud the nursing home and stop the nursing home from getting paid. Now, they had no facts to support this in their lawsuit. They had nothing to back this up whatsoever, and yet they threw that in there. And our client was scared to death of this. She thought she was being accused of fraud. She thought she could face jail time. And really, she had no interactions with the nursing home beyond the first couple of days of working with the social workers in the admission process. This all came out of nowhere. And luckily, she was able to get to us. We filed a motion to dismiss very quickly, and we got the case dismissed. And the judge we went in front of agreed with us that the nursing home's claims here were really based on nothing. They were just trying to seek a quick payment from someone, and they knew they would not be able to get anything from the resident's estate because the resident passed away without any income or assets to her name. So they were hoping to get a judgment and a lien against her family friend's home, which would have resulted in this senior also becoming homeless and needing to get her own care. So we were really grateful that we were able to get that case dismissed. And frankly, I was really disgusted by the lawsuit that was filed there and horrified that lawyers were engaging in bringing these, what I consider frivolous and illegal collection lawsuits. But when I started to dig into these lawsuits, I found that this was not just a one-off case of, a mistake that was made. In fact, I saw the same exact lawsuit copied word for word filed against hundreds of caregivers in, my small area in Rochester, New York, over a very short period of time. And that was frankly shocking to me. I work with bad debt collectors on a daily basis. That was, my bread and butter work. I have fought debt collectors who brought illegal collection actions before, and I had never seen anything of this magnitude go so unchecked for so long. I will tell you that I have represented family members who have tried in the admission process to not sign these forms, and who were told by the nursing homes that they had to, or their family member would not get a bed. I have had people who have sworn to me that they never signed anything. And when we looked at the admission agreement, we found that the signature was actually an electronic signature that had been copied and pasted from another document into the admission agreement. And that was the basis of the lawsuit against the person, saying that they signed to agree to be personally responsible for this. I've also had family members who have been sued who themselves only had income of a limited amount of public assistance. I saw one woman being sued for her late mother's nursing home bill when she only received $400 a month in public assistance benefits. Like, how is the nursing home thinking that they're going to get paid out of this? And why are they doing this to family members whom they know will not be responsible ultimately, and who are struggling themselves financially to take care of everything? The issue here, I think, goes down to the fact that these lawsuits are quick and easy for them to file. They're hoping to get default judgments. They're hoping to get settlements against family members, and they're hoping to get quick payouts, because going through the Medicaid appeal process can be very complicated. And also, nursing homes do not like to admit when they mess up the billing process or the Medicare or Medicaid application process. We have seen numerous times where Medicare was cut too early for a resident, and as a result, the transfer from Medicare to Medicaid maybe resulted in Medicaid being denied due to some, other asset issues or income issues. And that's why the bill accrued very quickly, and family members were being pressured into settling and paying those high bills, despite the fact that the nursing home mistakes probably resulted in the bills being so high in the first place. So it's really egregious what we are seeing, and we are fighting these cases, in the court system, but also as advocates across the country. Really, we are working with ombudsman advocates, elder law advocates, consumer advocates, and attorneys to try to make sure that caregivers and residents know their rights, that they're prepared when they go into nursing homes, that they know what they're looking at when it comes to these admission agreements, and they also know what to do once they are in that position where they're having to make sure that the bills are being paid ongoing out of the residents' funds, not out of their own funds, and how to respond when these lawsuits or collection actions are initiated. So what I will say is that we have a national coalition of attorneys working on these cases and policy advocates. So if you are interested in looking at what's happening in your area, I would start looking at the court records. And like Alana suggested as well, look at your discharge proceeding notices. If folks are getting discharged for non-payment, I bet you will try to very easily find that there's going to be some corresponding collection lawsuits that are being filed as well. Starting there, you may start to turn up a lot of these illegal collection practices that we are seeing happening across the country. And if you need assistance with that, our national group, which is just really very informal, you can reach out to me at any time. I'm happy to, connect with you on this and add you to that group if you'd like to, get assistance with those cases and get advice on what to do, and connections to local legal aid groups and private attorneys that may be able to help you fight those. So with that, I will stop there because I know we want to save time. But Alana, did you want to add anything else on what ombudsman and other advocates should be looking out for when these cases start to come up?
I think it's really just, I failed to admit my personal opinion when that CMS rule came out. I was like annoyed. I was very concerned about the influx of paperwork. I managed a very large program of 9 counties, and it had approximately 60 nursing homes. However, I'm here to tell you I'm really in support of that rule, and I'm just glad that I looked. And it's been very helpful to track the information, to be able to pull up an Excel document to see. I mean, I'm giving you data up until 2019, but it's only grown. So I really just think it's about observing. And my philosophy is somewhat like a stop, drop, and roll. Like I see this, now what am I going to do? I'm going, as I said earlier, go visit. I'm going to ask questions. And some of the questions are harder to ask, but I got very comfortable with the uncomfortable, and some of the questions are hard to get answers to, but really I feel our role as ombudsman at that time was really to be the connector, identify the problem, and then find the resources, which quite honestly, the most helpful one was to connect with the local attorneys. That made quite a difference for the residents, and it certainly assisted my role as an ombudsman. But thank you.
Thanks, Alana. And I know we had one question in the chat. I just wanted to quickly clarify. So the loophole on the third party clause, I just want to make sure everyone is clear on what that is. So while third party guarantees are banned in nursing home admission agreements, nursing homes are allowed to ask that someone sign a responsible party clause, and a responsible party clause can include basically an agreement saying that I am, the resident's responsible party. I attest that I have access to the resident's funds and assets, and I agree to use my access to the resident's funds and assets to pay the nursing home bill and or to assist the nursing home in getting paid through Medicaid or Medicare. That is legal and valid under the law. However, what we are seeing is then that nursing homes add in that if someone fails to pay the nursing home out of their access to the resident's funds, then that responsible party can be held personally liable for damages. And that's what's illegal, right? But we are seeing that getting snuck into all of these contracts, and that is what's becoming the basis for these lawsuits down the line. And that's what you really want to watch out for, and want to make sure that family members and caregivers are watching out for when they sign these admission agreements.
Thank you, Anna and Alana, for taking us through some case studies. Next, we're going to turn it over to Beverly Yang from the Consumer Financial Protection Bureau. Beverly?
Thank you, Lori. And thank you, Anna and Alana, for sharing your deep expertise on this topic, and also for your continued advocacy on behalf of residents and their caregivers. I'm Beverly Young with the Consumer Financial Protection Bureau's Office for Older Americans. My office looks out for older adults and caregivers. We help protect them from unfair, deceptive, and abusive financial services and practices, including the practices that were described today, through enforcement, rulemaking, policy recommendations, and consumer education. Today, I'll be talking about what my agency has done to highlight and address these nursing home debt collection practices, and I'll also be sharing some ways you can help combat them. Some of you have asked, well, how can we educate caregivers? I'll be talking about some ways that you can help. We have some tools and resources to share with you. So you might be wondering, wait, who's the CFPB? The Consumer Financial Protection Bureau is a U.S. government agency dedicated to making sure you're treated fairly by banks, lenders, and other financial institutions. We also regulate providers of financial services, and that includes debt collectors, which means that many of the attorneys who regularly sue family members to collect residents' debts are debt collectors regulated by our agency. The Nursing Home Reform Act, as you just heard, prevents a nursing home from requiring a person other than the resident to assume personal responsibility for any cost of the resident's care. That's out of the rule that CMS, the Centers for Medicare and Medicaid, wrote about. the law. And we're concerned about legal practices that violate these federal nursing home laws. Someone asked if this was, this violated the law across the nation. That is the case. We've spoken with advocates around the country, and it's been difficult to find an advocate who doesn't see this happening in their state. If you could skip to the next slide, please. I have to give a disclaimer. I wouldn't be a good bureaucrat if I didn't say that my remarks today are not the legal interpretation, guidance, or advice of the CFPB, and they are my own, may not represent the Bureau's views. So next slide, please. We are, as I described, we are here to protect you from abusive, unfair, unfair, deceptive, and abusive practices in the consumer financial services space. We can skip to the next slide. Okay, so here I'll talk a little bit about what we've done. When nursing homes bills go unpaid, some nursing homes hire debt collectors, including law firms, to demand that caregivers pay for a resident's unpaid nursing home bills. They may report the debt to consumer credit reporting agencies as your debt, as the caregiver's debt, and file lawsuits in court. Debt collectors may even tell the judge that the caregiver intentionally misused, hid, or stole the resident's funds without any reason for believing that they actually did, as Anna alluded to earlier. These actions could violate the Federal Fair Debt Collection Practices Act or the Fair Credit Reporting Act. So those are nationwide laws. We began speaking with aging services providers like Anna in March, and we learned that this was happening across the country. In early September, we released a report, a joint letter with CMS, and some information for state, federal, and private enforcers of consumer financial rights. And in the, I think that Lori's put a link to the slides in your chat. You'll be able to find links to each of these in the slides. The CFPB issue spotlight highlights how nursing home debts arise, problematic nursing home admissions contract provisions, their debt collection practices, and the difficulties that caregivers experience when they're pursued for family members' nursing home debts. Based on the findings in the report, the CFPB and the Centers for Medicare and Medicaid Services issued a joint letter reminding nursing facilities and debt collectors of their responsibilities under the Nursing Home Reform Act, the Fair Debt Collection Practices Act, and the Fair Credit Reporting Act. And to promote enforcement by state and other federal agencies, as well as consumer attorneys, like Anna, we released a new consumer financial protection circular explaining that attempts to collect debts from caregivers based on contract terms that violate the Nursing Home Reform Act or false claims of wrongful financial conduct may violate the Fair Debt Collection Practices Act or the Fair Credit Reporting Act. So in early December, we also published a joint blog with the Administration on Community Living and a fact sheet to help caregivers understand their rights and report federal violations. Finally, we're raising awareness among aging service providers through organizations like Consumer Voice, who are leading the charge in advocating for older consumers and caregivers. And we're asking them to convene experts so you can hear from peers with expertise. So next slide, please. Many of you are caregivers yourself. I've seen comments to that effect in the chat, and you may have caregiving family or friends, or as an ombudsman, an aging services provider, you can share information about this with your peers. We've got some tips on how to deal with illegal nursing home debt collection practices, and those are in the fact sheet, which I'll share in the chat later. Here's a very quick overview. You can watch out for words such as responsible party and joint and several liability in the contract. You can refuse to sign a nursing home admissions contract that tries to hold a third party personally responsible for the resident's bills. You can share our fact sheet with colleagues, and you can also get to know, if you're an aging services provider, or even just a caregiver, your local legal aid and other elder law practitioners, so that you can talk with them about these issues that you're seeing, and others that may arise, especially when it comes to discharge, and other issues that you're seeing in nursing homes. So I just wanted to, on the next slide, talk a little bit about our complaint system. The Consumer Financial Protection Bureau takes complaints from individuals, and then the complaint is sent to the company, and a consumer will receive a company response, usually within 15 days. If the company that's being complained about is a financial services provider. These complaints are very important. They help inform our work, which ranges from drafting rules, producing educational materials, bringing enforcement actions, and conducting supervisory exams. So we really encourage you to submit a complaint if you or someone you're helping is experiencing a problem with a debt collector. I wanted to give you a chance also to check out our other resources, which are available at consumerfinance.gov, Older Americans, and that's our email where you can tell us about what's happening. And then I think at this point, it would be best to move on to questions. Actually, before we do that, I just want to express my gratitude to Lori, Sam, Jocelyn at Consumer Voice for their hard work in pulling this together, to Sam, Anna, and Alana for sharing their deep expertise and their passion for serving older adults and their caregivers. And it was a privilege to talk with you today.
Thank you so much, Beverly. And thanks to all of our speakers today, Sam, Anna, Alana, and Beverly, for their informative and engaging presentations. I know I learned a lot today too, and I'm glad to have those of you here with the expertise that we have. We do have some time for a couple questions, and why don't we start? There was one that was early on, Beverly, that you had started to respond to, which was if these provisions are not allowed, are they valid if signed? And you had started some answers to that, but maybe could you just talk through a couple of those?
I sure can. So I saw a question about whether these terms in the contract, if they're not allowed, then are they valid if they're signed? And what we've seen is that courts have found these terms unenforceable when the caregiver fights back, often when there's a lawyer involved. So when a caregiver gets a lawyer like a legal aid attorney, then the nursing home may back down from their claims. But in the vast majority of cases, we suspect that caregivers don't have a lawyer, and courts are entering judgments against people who can't fight the case on their own. So that's why it's really important to take a look at the contract before signing it, and then also to reach out to local legal aid and elder law attorneys, because it may be well worth it.
Mm-hmm.
And I would just like to add, if that's okay too, that even in states, and I live in a state where the courts have upheld these contracts, despite the fact that I think they're on the face illegal, that does not mean that your caregivers and family members who are being sued will automatically lose. Just the opposite, because when I have litigated these cases in the court and showed the judges exactly what these residents and their family members are being sued for and laid it all out for them factually, they get it. They understand, okay, all right, so you're suing a woman for breaching a contract despite the fact that you never sent her a bill and that she never had access to the resident's bank account. How is she supposed to have paid anything here? That really clicks with these judges. So even if you're in a state where you have bad case law, you still can fight it. You just need to get them connected with an attorney, and an attorney who understands this quickly.
Thank you.
Exactly.
Beverly?
There was a related question about whether this is illegal in every state, and we're talking about the federal law, so it's across the nation. So it is illegal across the nation. And, you know, I think that the question of educating more legal aid lawyers and judges about this is, you know, that is something that we find important and something we're working to do.
Mm-hmm. Great, thank you so much. One question, we get this a lot, is do the provisions we're talking about today also apply to assisted living? Sam, do you want to address that or start that?
Sure, it's a quick, I mean, at least the provisions we're talking about today are federal and certainly only apply to nursing homes. Unfortunately, the federal government doesn't regulate, although we think they should, they don't regulate assisted living facilities. However, that does not mean that state law may not govern some of these issues. Of course, that would be dependent upon the state in which you live. But what we're talking about today is particular only to nursing homes.
Mm-hmm. There were a couple questions about whether there have been any countersuits for frivolous or illegal lawsuits by nursing home agencies. Anna, could you address that?
Yes, there have been, and we are starting to see more of these, and that's something that our group is working on, bringing more of these cases to sue collection lawyers and nursing homes for these illegal practices. One thing that I will say is that those cases are very hard. It's just the state of the world we're in today with bringing those types of lawsuits. They're very hard to win, but it is important to bring them. I will also say that it's very important, if you're seeing these, to file complaints with your state attorney general's office and with the CFPB, because if that's not something that an individual can maybe win and bring an individual lawsuit, it may be something where a regulatory authority or the AG's office of the CFPB might be able to bring an enforcement action and issue fines against an agency or a law firm for these illegal collection practices.
Mm-hmm. Thank you, Anna. Jocelyn, do you have one primed that you think would be good to go to a question?
Sure. So two actually that I think go together. And I know, Beverly, you did talk about this a little in your presentation, but I think we should open it up to everybody. Because at Consumer Voice, I know we talk about this a lot internally, and I know we talked about this in advance of the webinar, but how do we educate families and residents about these rights before they sign the contracts? Because again, with Ombudsman, you usually aren't in touch with your Ombudsman until after you're in a facility. So I wanted to ask that. And then also somebody asked in the chat, can a family member add a statement stating that they are not responsible? And I assume they mean to the contract itself. And so I guess the question is really, you know, how do we educate families and what do we tell them to do when they get into the nursing home and they see this right there in front of them?
Can I address the second part first? Because I think that's
Sure.
a little bit easier. So yes, we have seen residents, and we encourage residents and their family members, as they're going through these admission agreements, sign things that you don't sign things that you don't agree to. Cross them out if you can. But you are often in the position where the nursing home will tell you, you can't make any changes to this contract. You can't have a lawyer review it. You have to sign it as is. It's a contract of adhesion. You're being forced to sign it as is. And if not, you will not get a bed. Now that's illegal. They're not allowed to do that, but it happens. And if your choice is not getting your loved one into the facility that they need to be in or signing this contract, we've seen it over and over again where people will just sign it. I will say, if you're in that position, or if you're working with someone who's in that position, once you've signed that, you need to know what's next. You need to make sure that you're staying on top of everything, that you're documenting everything in writing. You're emailing the business office at the nursing home to make sure that they have everything they need and there's no outstanding bills. You want to make sure you're in constant communication so that if you are sued down the line improperly, you have all this documentation to back it up that say you did everything that you were supposed to do and it really was not your fault that it ended up here, and you should not be held personally responsible for that.
Thank you. There was another part of the question. Jocelyn, can you read that one again?
Sure. That was just a little bit broader. It was really how, and I'm looking for it now as I scroll through the chat, but really the point is like, how can we educate people about this so they know going into a nursing home what to be looking for? We know there are a lot of provisions in contracts, like you said, Anna, that you might not want to sign, that you might want to cross out. You know, how can people, other than attending a webinar like this, really learn what they should and shouldn't be looking for in a webinar? Where should they go before they are looking at nursing homes to get that information, I guess?
Any of our speakers want to start with that?
Yeah, I'll say it's tough. I mean, as a lawyer, we always encourage anyone who has the ability to work with an attorney or an elder law advocate at your local legal aid office, or if you can afford to hire a private Medicaid planning attorney to help you walk through, so you know that you're prepared. You need to make sure that you are ready if you are someone who's anticipating needing care yourself. Just preparing in advance as much as possible is always best. But unfortunately, that's just not the reality of the situation we're in today. Most people enter long-term care facilities and nursing home facilities in a time of crisis. It's not something they've planned for. It's not something that they have resources set up to assist them, at home, to make sure that everything is done correctly. And really, I would say the onus needs to be put back on the nursing homes. They're the ones who have all this information. They're the ones who know how to engage with Medicaid and Medicare. They are the ones that should be doing more to educate residents and their family members on their rights and responsibilities. And that's something that I think that regulators can really start enforcing and making sure that nursing homes are the ones who are actually informing residents and their family members of their rights.
Yeah, I just wanted to say one thing really quick here too, is that these are also complaints that can be filed with the state regulatory agency or CMS, and that's important. I mean, I know there's a lot of ombudsmen on the call here, and you may not be able to get to folks beforehand, but if you're identifying facilities that are using these type of contracts, and you're hearing from family members or residents that they're occurring in those contracts, get the contract, have the family member or the a resident file a complaint with a regulatory agency. I know it doesn't always work out, but that's another way to try to stop it. If you can't, because you're not going to get to all residents and family members beforehand, but you may be there ex post facto and be able to get those agreements to the state regulators. Sorry, Beverly.
Oh, that's fine. Thank you, Sam. I think that what you've pointed out, Anna and Sam, that they're really, there's an unequal relationship between the nursing home and caregivers who are coming to them with a resident, and nursing homes are in a position of power, and people often just assume that the nursing home, what they're doing is legal, and so there needs to be systemic change across the industry, and that's what we're trying to do with our advocacy with the Administration on Community Living, and with the Centers for Medicare and Medicaid. I also want to mention, when Sam said you can report nursing homes to your state survey agency, we actually have resources for reporting to a state survey agency, getting legal help, finding your local long-term care ombudsman, which is you, and submitting a complaint in the fact sheet. So I can put a link to the state survey agency directory in the chat, but you'll find everything in the fact sheet itself.
So the resources that we have been talking about today have been linked in the chat with the slides, and also they'll be available on the Consumer Voices website after the webinar, and they're available on the CFPB website as well, so you can access them there. We are past time, and unfortunately, I know there are a lot of questions we didn't get to. Shows that this is certainly an issue of interest for our attendees today. So thanks to all of you for joining us. And thank you so much to Anna, Alana, Sam, and Beverly for your presentations today, and to Beverly and the team at the Consumer Financial Protection Bureau for reaching out and partnering with us to provide this program today and to support these activities. So thank you all very much, and look forward to talking to you all again and working with you on these issues.